Let me first of all introduce myself. My name is Alan Feuerstein, and I'm a lawyer. I've been practicing law since the 1970s, and my offices are in New York, Washington. We have an office in San Juan, Puerto Rico, and I reside in the U.S. Virgin Islands on the island of St. Thomas. Let me preliminarily state that much of what I'm going to be talking about involving my client, Richard Vento, and his family, that includes Lana Vento, Gail, Nicole, and Renee Vento, and I'll refer to them as the Vento family, that ordinarily would be covered by protected attorney-client communications and issues that are ordinarily confidential. As a result of the invitation that we received a few months ago from Dave to come to the conference here today, we discussed this with our clients and decided that what we're going to disclose, although ordinarily confidential and protected, is able to be disclosed because, and the disclaimer will be that the comments that I make are opinions. The information that you receive are publicly available, and everything that we tell you is true. By way of background, I have been a trial lawyer since I started practicing law in the 1970s, and I started working with lawyers when I was relatively young. I had a fascination with the law when I was about 16 years old. And I decided that after I was admitted to practice and after I clerked for a federal court judge in Ohio and clerked for a large law firm in Buffalo, New York, that I would teach for a while. And I taught trial practice at the University of Buffalo, Faculty of Law and Jurisprudence, and I was running something for the Bar Association in Erie County that was called the Pretrial Services Agency. This introduction, prior to actually going into the courtroom and trying cases, I think was essential in the way that we have been successful in handling matters for individuals, for clients who are primarily families, for people who have been victimized, and for the general public. One thing that I tell juries, and it's interesting because I think we've got about 12 right now, and that's usually what I talk to. That's about the number in jury trials. What I usually do is I try to explain how important the jury system is in our country. I consider this to be one of the final vestiges of justice that individual citizens have, because what it does is it allows us to erect a wall between what is just and what is unjust. I recall reading years ago that in colonial America, that when the people decided that they were going to have jury trials, and they had a jury trial, and the verdict came back, either guilty or not guilty, if the Crown did not like what the verdict was, that they would rearrest the defendant anyway, and then they would also arrest the jurors. Fortunately, we have jury trials, and that, in my opinion, is the best way that we can judge the issues that are before us, before the public, and it gives people a voice. In my career, I've had a number of civil racketeering cases. I've tried personal injury cases. I've had cases involving individuals who have been horribly injured, families who have been horribly caused to suffer as a result of negligence of others. And what I've been able to do is develop what I call a template when we're involved in investigating, prosecuting. I'm usually on the plaintiff's side, although I have defended cases. The major cases that I've had as a plaintiff in practicing in federal courts, I've tried cases in more than 26 states. I have a pretty good record of success in every civil case that I've had. I think one of the first racketeering cases, civil racketeering cases, and I'm talking about the RICO statute under 18 U.S. Code, Section 1962. Most states have their own RICO statutes that allow you to proceed in state court, but the federal statute also allows you to proceed with the federal cause of action in the state courts as well. First one that I had was probably close to 20 years ago. It involved the manufacture of little heaters called Polonus heaters, and the manufacturer was a company by the name of Shiho Trading Company. Shiho was owned by a woman, Eliza Lee. She was about 4 foot tall, had a photographic memory, lived in Taiwan, and she was a manufacturer. They took parts and they put them together, and they had put together these little heaters, and they sold them worldwide. And she was dealing with a company by the name of Delrain Corporation. Delrain Corporation was selling heaters around the world. They would have to just change the electrical systems so that they could accommodate different places like the Netherlands and the U.S. and Argentina, other places where they have cold weather. So Delrain Corporation started giving to Eliza Lee false payments. They would do that by SWIFT. They would do that by promissory notes, the types of things that a manufacturer obviously does not want to be involved in. So she was on the hook for millions of dollars to her suppliers, and I got involved in the case and tracked it down. It was one of the first international cases that I handled years ago, and we were able to recover for Eliza Lee, despite the fact that the defendants filed a bankruptcy petition. And we ended up forming another corporation that went into the bankruptcy court and purchased the assets of Delrain Corporation by using the false notes that they had given to Eliza. From there, we had other cases, one called Lenchishin. It was a Canadian case I handled in the U.S. for a man by the name of Michael Lenchishin against another manufacturer. Cases in Puerto Rico, where I also practiced law, involving other claims of racketeering. Most recently, in the U.S. Virgin Islands, we just 2 weeks ago resolved the case against Banco Popular, where there was a corrupt bank officer who became a financial advisor. At the same time, he was acting for the bank and loaned monies, and the bank started a foreclosure action. We commenced counterclaims based upon the racketeering statute, and we were able to recover all the properties and cancel out all the loans that the bank had given, because the bank simply did not want it exposed that their regional manager had been involved in corrupt practices. RICO statute can be like a sledgehammer. When you sue these cases, you are really sending a chill up the spine of the defendant, because once that word gets out into the public, and once the press gets a hold of the claims, and they are all public because we file them in the federal district courts, they're not under seal. The press will look at this and they will publish articles that simply mirror the allegations that are made inside of the pleadings. You may recall that not that long ago, Alan Dershowitz went crazy because they were alleging that he was involved in molesting or having sexual relations with people who were underage over at Mr. Epstein's Island, which is right across the street from me in St. Thomas. What is ordinarily published in pleadings that are filed in federal district courts and in state courts, the allegations that are contained in those pleadings, they are subject to the doctrine of judicial immunity. So you can put just about anything that you want. If you're a lawyer, and if you're an ethical lawyer and an honest lawyer, you can put just about anything you want if you have a valid basis for putting it in, you've done your investigation. And then the press can then take what you say and put it into their publications and essentially quote you. It can have a devastating impact. It can be a very unethical thing for lawyers to do who want to get leverage, and it also can be utilized in order to expose those fraudsters who are out there doing things to your clients that should not be done. So after handling cases involving racketeering for some 20 years, and also handling other complex commercial cases and civil cases, I started to develop templates so that we could analyze the cases, so that we could make a determination as to whether the cases that were presented to us that we would consider handling could be properly investigated. And what we do in our practice, and we've got 26 employees in New York. I've got 3 partners right now. We've got support staff and paralegals of about 8. What we do is we take the case and we analyze it, first of all, factually. We want to find out who our clients are. We do and perform our due diligence so that we know exactly what is being alleged, whether the allegations constitute valid claims or causes of action that we can pursue, what types of damages we are entitled to for our clients if we're able to prosecute the case, if the case can be prosecuted successfully, if we can comply with the burden of proof that we have, and in the civil system it's, I call it a more likely than not. I'm not sure how many lawyers we have out here, but if I'm getting a little bit too myopic, you can let me know. In a civil case, the standard of proof is a preponderance of the evidence in the United States. That's the standard that is used in civil RICO, also conversion, also other tort cases. Criminal is beyond a reasonable doubt, so the level of proof is just a slight tipping of scales. And analyze to see whether the proof that has been given to us by our clients warrants the type of investigation that's needed so that we can further ferret out the actual evidence and the testimony and the documents that are needed. When we're dealing with this type of a case, and I'm going to introduce my client, Dick Vento, in a second. When we're dealing with this type of a case, and the Vento case has become well-known throughout the United States because of the recoveries that we've been able to receive. What we want to do is we want to first of all see whether it's worth it, because we're dealing with a very, very labor-intensive type of situation where before we commence our action, we better be damn well that we have got enough so that we can surpass the motions that are going to be brought under 12b-6 of the federal rules, motions to dismiss, motions for summary judgment, motions based on jurisdiction. And when we're dealing with large players, when we're dealing with insurance companies, when we're dealing with banks, and we're really the little guy, we've been victimized, we're a family, we're individuals, we've lost our leg, for example, or our lives, or our livelihood, or everything that we have ever worked for in our life, and that has been taken from us. And we as lawyers come in, and we have to make a determination as to whether the advice that we give our clients as to whether they should proceed on this case is in their best interests. And obviously, we also have to figure out whether it's in our best interests, because you cannot get halfway or a quarter of the way through a case and be faced with a situation where there is not enough funding in order to proceed. What we do in every racketeering case that we have is we have an in-depth investigation performed by professionals, by people who we've used before, by people who we trust and by people who are good. We have certain investigators who we've used in different types of cases. In the Vento case, we used retired FBI agents, people who we had used before, individuals who were part of a network and are part of a network of retired FBI agents, DEA agents, who maintain relationships with other agents throughout the United States of America and in foreign countries. So I called Pete on the phone after Mr. Vento contacted me, and I sat down with Mr. Vento, and he said to me, yes, I want you to look at this case, and I want you to make a determination as to whether, if we proceed on this, where are we going? We have lost, and at that point it was about $34 million of investment, and for a family, that is a lot of money. For most people, that is a lot of money. An investment to proceed on a case like this would require that your client be willing to invest somewhere around $1 million in order to get the case to trial and through trial, and to secure the evidence that's needed, the witnesses that you have to have, the expert witnesses. But step number one in any of these cases is making sure that by the time you get that judgment, you're not holding an empty bag or a leaky bucket, because it doesn't make sense to lose $34 million, spend another $1 million in attorney's fees, and have nothing at the end. So our investigation not only involved the facts and the liability of the Vento case, which was very interesting, and I'll get into that with you a little bit later, what was revealed as a result of investigations that we performed in the other victims who also were seated in the same positions the Vento family was. But it also allowed us to determine whether there was enough gold at the end of the rainbow so that we would be able to satisfy the claims and the judgments that we were able to obtain. So that's where we started, and I called Pete on the phone, and I said, hey, Pete, this is what we're doing, and I want to know about Fidelity Insurance Company, a company that is incorporated on the island of Nevis in the Caribbean. The players in the Vento case were essentially what I call look-alike companies. Some of what I'm going to tell you may astonish you. It astonished me. I'd never seen anything like this before in my life. When an insurance company starts up and names itself Fidelity, what you automatically think of is, well, it must be Fidelity. It must be Fidelity Investments. This is a substantial company. They're never going to breach the obligations that they have with their policyholders, because that will run rampant around the United States. Their reputation will be shit. And what happened with the Ventos was amazing. So getting back to the investigation, what we did was we hired our investigators. They went out and they literally ripped apart this entire organization, this entire enterprise, each and every player, who they were, where they came from. How do you do that? The way that Pete did this, by using his contacts, is unique. Some of the things that he found, he cannot tell me how he found them. They were true. I found, for the Vento family, for example, in Belize, the amounts of monies that lawyers held in their trust accounts, the names that were in, that these monies were held in. And the way he was able to do that was he did searches on a law firm to find out where they were representing people in foreign countries. They found a development. The development happened to be in Belize. They then went to the web and they looked to see what banks were doing business in Belize that were within walking distance of that development. They then, through international contacts that they had, and some of these people were involved in the prosecution of money launderers, they went to their quote-unquote friends and associates and they said, can you find out whether Tom Handler, Jim Duggan, Steve Thayer, or Handler, Thayer, and Duggan, or a company called BPP, have any deposits in this particular bank in Belize? Within 24 hours, we got hits. We got 7-figure hits on bank accounts. How they did it, I don't know. Were we able to get it? The next thing we do is we serve subpoenas after the litigation has started, because it's very difficult to get pre-action subpoenas issued in foreign countries, unless you're a real magician, and maybe your name is Mareva. What we were able to do is, after the action was commenced, we were able to serve subpoenas, and everything that they advised us of turned out to be correct. We then attempt to freeze these assets, and even if you don't freeze the assets, because the lawyers, once they're sued, because there's a very, very interesting corruption element and the way that they lure the fish in, what you're able to do is follow it. Went from one account. Pete, where did it go? He's got the next account. I'm not going to blather on and on about what a great lawyer I am and tell everybody about all the great cases that I've won, because this case and this lecture is primarily about the family office nightmare in the Vento family. And so I want to introduce Richard Vento. Richard Vento is my client. Everything that he's going to tell you is true. Ordinarily would be covered by confidentiality, but Dick, would you please just stand up, introduce yourself, and tell everybody a little bit about you.
Okay. I'll make this part quick too, because you're probably interested in what we did about the mess. You're probably interested in what we did about the mess and not how we got into it so much. I was born in Colorado, raised in Palo Alto before Silicon Valley really got started. Watched Silicon Valley evolve. Was deeply involved in technologies all my life. Went to college and got degrees in art, math, economics, statistics, fulfilled the requirements for business degree too. Took every data processing and programming class I could find. When I got out of college, the highest paying job I could get was a programmer. Worked for Wells Fargo Bank for a while. Got the first programs to work on IBM 360. Went to Signetics Corporation, which made chips for high reliability chips for spacecraft primarily. And left there and went to work for Timeshare, TYM. It's like a baby cloud. Today our cloud covers the globe. That was a computer located in Los Altos that you accessed by telephone lines and acoustic couplers, and it made little squeaky noises like you get in a fax machine. It was pretty slow. You know, that computer over there has more memory and more speed capability than those things did in those days. But it was a very interesting company. It covered a lot of applications. And that's where I had my first stock option. And from then on in my career, I had stock options wherever I ended up working at Cybernetics in Ann Arbor, Michigan, and other places like that. I ended up at Computer Sciences Corporation, where I got my last paycheck that I didn't pay myself. And from there on, went into business for myself, and almost went broke a couple of times, but made some successes in various companies. Primarily, the successes were centered around deregulation of the phone companies. You know, at the time, everybody needed billing systems and traffic analysis systems for what kind of networks that you need to accommodate the loads that were in your networks. We sold about 153 billing systems at one point in time. Then American Express came to us and said that they're building a multi-device, multi-component system network, including a fiber optic network around Manhattan and wanted us to build a multi-vendor, multi-device network management system. They couldn't get one from IBM, Northern Telecom, AT&T, or any of the big guys. Nobody wanted to touch anybody else's equipment. So my partner and I said, this is perfect for what we wanted to do. We were at that time running a company called Objective Systems Integrators. We integrated the Unix operating system, both graphical user interfaces with artificial intelligence and a bunch of other things, object-oriented programming that went on at that time. And I won't go into all the details of what that technology is, but it all came together at once, and it was a beautiful opportunity to build a system that managed, monitored, and controlled the world's largest networks. And we did that in that company. That company merged with a company in Boulder, Colorado. And it wasn't going the way Tom, my partner, and I really wanted to go. So we left there and formed our own company. We ended up in network management competing with them, with that company, and beat them a couple of times in competition. It went on to manage and control DISA, which is the Defense Information Systems Agency, one of the biggest networks in the world, if not the biggest one. And MCI, Sprint, AT&T, NTT in Japan. It was pretty much the who's who of the telecom industry. By that time I had formed LLCs and moved about 48% of the ownership under the Unified Tax Credit to my daughters. Had a lot of LLCs in place for estate planning, things of that nature. We knew we were going to go public, and eventually. And so I set up some dynasty trusts. So did my daughters. Okay, and we made grants to them, to the trust. We set up annuities, insurance policies, and a few other things. We went public with that company in 95. George Soros's Chatterjee organization put in $10 million, and Javco, Japanese Asia Pacific venture capital company, put in $10 million, and that gave my partner and I some liquidity before we went public. So there were some private equity in there, but other than that, my partner and I started it on $270, and we sold it for hundreds of millions of dollars. And that led us to a big tax problem. The income from the sale occurred in 2001. Most of our tax planning was done in 2000. But LLCs don't recognize their income till the end of the year, so I had a little bit of breathing room. The other things that we set up, sometimes they were like the annuities. We did those in a big hurry and really didn't finish them. We also ended up with LLCs that had collector cars and stock and all kinds of different things in them, some of them high liability, some low liability, so we needed to reorganize it, okay? And I'll let
Dick had a capital gains issue.
Yeah.
And the capital gains issue was significant, but in anticipation of the sale of the OSI stock, he had tax planners come in, attorneys come in, and give him advice regarding private annuity agreements that were
Right.
something that would be allowed to be used by the Vento family to defer the capital gains. And there were assets that were transferred in on the advice of lawyers who specialized in this area.
Yep.
I think one of the companies, the insurance company that was holding the private annuity agreements was Lighthouse in the Cayman Islands. Am I right?
That's right.
Okay. And then
Yeah.
tell us what happened after that.
Well, there was a need. We had a family office at that point in time. Do these need to be moved up to the no. Things? Yeah.
Okay.
Well, I'll let you get into these characters that are right here, but the situation, the reason I got into all this is that some of the estate work that we had done was getting messy. As I said, there was one LLC that had been around since the 90s, before we went public, and my daughters each had their own LLCs. And they had the wrong types of assets in it to be together, high liability and low liability. The annuities would have paid my daughters over $700,000 a year. These kids were in high school and college, and I don't think you want those kids to get $700,000 a year. Their husbands would never work again, the ones that were married. and I'd get a lot of money. So one of the things we didn't do that we wanted to do was to set up additional dynasty trusts, or trusts for the kids. The ones we set up initially, which were with Citicorp, only paid for education and health care. And they were big enough that the kids with family had to be rabbits to reproduce fast enough and be very sickly and geniuses to go to college forever, and to use up that money. And then it would also roll over into charity every 20 years or something of that nature. So we needed to get some additional trusts that would cover more things than that those initial trusts would do. And we needed to get the LLCs cleaned up such that we didn't have so many. We had like 40, 50. Okay, even the stock accounts, we had about 40, 50 of those too. That was all silly. It was a lot of work for the stockbrokers. So we were looking for a family office attorney. We had Debbie Cochran, who had done the original trust. We had Bob Colvin, who had done the annuity insurance policies for offshore. We went offshore not just for asset protection, but I believe some of the things that we were looking for there was premiums in kind to set up policies so that assets would sell under the wrapper of the insurance or the trust or whatever, and have a better tax position. The attorneys will have to tell you all of that. But we really had a big mess that needed to be cleaned up. So we were at a family office forum in Florida and met a guy named Tom Handler. He had a company in Chicago that was supposedly a reputable firm for family offices. We told them what our situation was, and they said, yes, we can clean all of that up. We can make some changes offshore. We can set up new LLCs and consolidate those for you, set up new trusts, and it all sounds wonderful. We did our due diligence on the company, not on the individuals, and my advice is don't ever do anything in a hurry. You know, anytime you do it in a hurry, you might miss something in the due diligence. And also get second opinions. You know, we thought he looked very good, and it wasn't all that good. Okay, he had lost his ability to be attorney for about a year. I didn't know that at the time. Had some other clients who weren't very happy with him and suing him at the time. And I think I'll let Alan take it from there.
Thanks, Chuck. I think if we kind of jump back a little bit, you'll understand that Mr. Vento and his family, as a result of a dint of hard work and a little bit of luck, ended up amassing a tremendous and valuable company, Objective Systems International, that was eventually sold to Agilent Industry for hundreds of millions of dollars. And in order to plan ahead, the Vento family sought the advice of well-respected and well-qualified tax advisors who could explain to them and implement programs that would allow them to avoid the payment of capital gains immediately and instead defer them through private annuity agreements that were erected on the island of in the Cayman Islands. What happened was that there was some disagreement with respect to some of the information they were receiving from Lighthouse Insurance Company, and that's that was really the reason that the Ventos went out to look for different tax advisors. Now the way that this worked was that Mr. Vento was introduced to a law firm, and the law firm was able to gain his trust. They presented themselves at family office seminars. The family office seminars were put together and presented around the country. The one that Mr. and Mrs. Vento went to, I believe, was in Palm Beach. And they were convinced that it would be in their best interests to switch from their advisors and go to another law firm. And I'm going to jump ahead for a second here. The lawyers were frontmen, essentially frontmen at family office seminars, and the Ventos did not know at the time that they had relationships with other clients of theirs that would allow them to engender fees if they were successful in steering their clients to Fidelity Insurance, First Fidelity Trust, Westminster Hope and Turnberry, a number of companies, entities that were essentially look-alike companies. Mr. Handler, the head of the firm, Mr. Thayer, a partner, and Mr. Duggan essentially surrounded Mr. Vento while he was at one of their seminars in the Bahamas and explained to Mr. Vento that the advice that he had previously received from his lawyers was bad advice, that the documents that were prepared incorrectly. They gave written opinions with respect to what should have happened, and they convinced the Vento family that the insurance company that was holding the funds that were being administered by a trustee in the Cayman Islands, that they should move those funds and they should move the administration of the trusts to Fidelity Insurance and First Fidelity Trust. And what we have up here is the 2005 brochure from one of their conferences that describes the Asset Protection Trust and explains, among a lot of other things, that you as the beneficiary of this trust and series of trusts you're going to, first of all, be able to control all the money in the trust, because the trustee is going to take instructions from a couple people. One would be a trust protector, and then the law firm named themselves as the trust protector, and also a financial advisor who would be in charge of administering the investments that are made with the $34 million. So the Ventos decide they're going to take the advice of Handler, Thayer, and Duggan, these lawyers, and you can see that here is a copy of the first pleading that we filed. Now, this was after a lot of due diligence was done. This was after we found that there were assets. This is after we received professional opinions from specialists in professional ethics, tax, financial advisors, lawyers, indicating that what had been done was a violation of the Code of Professional Responsibility and caused them to be personally liable as a result of the advice that they had given to their clients, including advice that they move from an unrelated company to a company that is represented by Handler, Thayer, and Duggan. And that would be the, it's called the Alliance Group of Companies. This lawsuit was started after there were threats made, and in retaliation for bringing this lawsuit, the expectation that we had that the matter would be able to be resolved was drastically diminished, because what they did was they attached to their pleadings in the federal courts confidential attorney-client tax memoranda, and indicated through their lawyer that the Handler, Thayer, and Duggan law firm was outraged that the Vento family would allege malpractice, breach of fiduciary duty, and that they would continue to disclose confidential attorney-client information in order to defend themselves, and that they had every right to do that. Well, we ended up continuing with the action, And the due diligence that we had done before included the language that was in emails that went back and forth that actually called the clients that they have big fish. And we also found payments from Fidelity to Handler, Thayer, and Duggan for, they called them retainers. But one payment was particularly interesting because it was over $700,000, and that $700,000 came in within, I believe, 30 to 60 days after the Vento moved their money to Fidelity. Now, it doesn't take a genius to figure out that there's a commission being paid. So they could say whatever they wanted to say, and we got involved in some heavy litigation with them. They refused to turn over documents. Finally, they turned over the documents that we were requested. In federal litigation, you've got essentially three different types of discovery that you can use. One is called a request for admissions, admit that you are this, that, and the other thing, and then they have to respond. If they don't respond within a certain amount of time, then the answer is deemed to be admitted now. I think it used to be deemed denied. The document productions, we received piles and piles of documents. The Handler, Thayer, and Duggan litigation that was started, I think there were about 200,000 documents that were produced in discovery. And then we took their depositions. All depositions that we take in racketeering cases are done by video. The reason they're done by video is because you can use those depositions at the trial that's going to come later, and you can actually see the responses that the individual is giving on videotape to the questions that are put to you. The Handler, Thayer, and Duggan defendants, many of them ended up taking the fifth. They would refuse to answer based upon their rights to not incriminate themselves. And once they do that, there is an implication that the law allows you to use in federal rules of evidence. That Fifth Amendment claim can be used against them. The jury can assume that their response would not have been favorable to them. There's a specific instruction for that. So we kind of look for that. Now, at the same time that we are proceeding with Handler, Thayer, and Duggan, because I'm looking for a weak link, I'm looking for someone who can break the back of the main defendants. We're also looking to see where the defendant's money is, and Pete's on that. And Pete finds that even though these companies are incorporated in small Caribbean nations like Anguilla, like Nevis, St. Kitts, even though they have their seatbed of operations there, all of the individuals who run these companies are American citizens. I want to know where their income is coming from. As a lawyer who used to be an investigator, I want to know where is that pot of gold at the end of my rainbow. If I don't settle this case, I want to know where I'm going to get my judgment satisfied from. So what Pete does is he finds out where the checking account is, where Dwayne Crithfield, where he gets his money to pay for his electric bill. He goes to the electric, he uses his resources, he gets the application. He then goes backwards. He sees in order to apply for his electric bill, or for his Rolls Royce, or for his home, or for his villa, that he has to fill out a credit report. He's going backwards. And then he finally finds out where the funding comes from, and he tracks the money, he follows the money, and he finds out where the income is coming from, and where these investments are. And finally, we're able to track. Now think about this. If you're a crook and you're operating on the island of Anguilla, there are not a whole hell of a lot of places where you can put your money and get a lot of return. Where do you get your return? The United States. Where do we find the money? The United States. It took a lot of work, a lot of documents, a lot of records. Every one of them thoroughly scanned, reviewed, collated, chronologically assembled, so that you can then go back and see what these people do every day. So while we're proceeding against the weak link, Handler, Thayer, and Duggan, hoping that they're going to blow the whistle on their clients, and despite the fact that that's what we're trying to get from them in their retaliation against the Vento family by saying, here's what you get. Confidential attorney-client documents attached to our pleadings. Who gets those pleadings next? Well, the Ventos are not shy, and if they do not believe that they owe Uncle Sam what Uncle Sam says, they're going to contest it. They have every right to do that. Tax avoidance is legal. Tax evasion is illegal. The Ventos, like any sophisticated person here, will do their best to reduce the amount of tax that they have to pay legally. So if the IRS says, you owe Y, and I say I owe X, you can take them to the district court. You can take them to the tax court. Because we're in the Virgin Islands, it's a little bit easier because you don't have to pay in order to get in the district court. So the Ventos are fighting with the IRS on issues, and lo and behold, what's one of the pieces of evidence the IRS comes up with? The attachment to the publicly filed document in the case of Vento versus Handler, Thayer, and Duggan. We make motions for protective orders to try to do everything that we can to stop it, and you've got district court judges who are obviously pro-IRS and anti-taxpayer, so it's in. At the same time, we're proceeding against Fidelity. We're proceeding against Alliance. We're proceeding against First Fidelity Trust, Westminster Hope, and Turnberry. We're proceeding against a lot of companies. And it all boils down to these three professionals. Dwayne Crithfield, Tampa, Florida. Steve Donaldson, Tampa, Florida. Keith Lee Lake, a lawyer, educated in the United States, used to be general counsel it'll come to me, but originally from the island of Anguilla. The seatbed of their operations, Anguilla, where they have some very interesting statutes. And you find most of these statutes throughout the Caribbean under what are commonly referred to as Confidential Communications Acts. So this group has put together what ended up being one of the most incredibly complicated scams that I have ever seen in my life. And the Ventos were not the only victims. Mr. Crithfield and Mr. Donaldson are presently under indictment in Tampa, Florida. A superseding indictment was just filed against them a few months ago, and I know that they're engaged in discovery because we follow everything that's going on with them on PACER, which is the federal reporting system for all cases that are pending in the United States of America. In any event, it turns out that Handler, Thayer, and Duggan, and Dwayne Crithfield, Steve Donaldson, and Keith Lee Lake have been putting on seminars throughout the world. We have their brochures from Singapore. We have their brochures from Atlanta, Chicago, Nassau, Cabo. And what they do is they advertise, and they say, we will manage your funds. We will put together an asset protection trust. Your trustee, you will be able to control through your investment advisor, and you will then have even more ability to make sure that your money is safe because you're going to have a trust protector keeping an eye on your investment advisor and your trustee. They do not tell you that this is part of one large enterprise, and it is a criminal enterprise. The goal that they had, and they still have today, is to divest as much money as they possibly can from wealthy individuals in the United States of America and shift that money and the size of that money. And now they're getting a little bit sneakier because they're saying, we don't need to actually have your money. At one time they needed to have the fund. Now all they need is the title. And we will then manage your funds. We will give you statements. You will see every penny. But what they do is they bleed and bleed and bleed that fund for undisclosed commissions. Right after the Vento money went over to Fidelity Insurance Company, right after, a new Messerschmitt helicopter was purchased, a new Sky King, a new Rolls-Royce Silver Ghost was purchased, new apartments, condominiums. In other words, what they did was they took that money and they converted it and used it as their own. You can never find out where that money is. It is not disclosed, and it lines the pockets of thieves. The complaint for civil racketeering, and you can see that it names the Vento family individually. In the complaint, it describes them in various different positions that they hold in entities. And then you have the defendants: Crithfield, Donaldson, Lake, Alliance Holding, Alliance Royalties, Alliance Royalties, Inc., Westminster Hope and Turnberry, First Fidelity Trust, Fidelity Insurance, Foster and Dunhill. It goes on and on. Some of these entities might look familiar to you. If you're confronted with a situation where at a seminar you have, for example, a former IRS director who is talking about what a wonderful deal this is, you probably, in your mind, say to yourselves, well, that's Fidelity. Now, maybe, as Dick says, he should have been more careful. Maybe he should have seen, well, let me see your certificate of incorporation. Let me see your license to do business. Let me see your good standing certificate. They didn't show any of that. They just called themselves Fidelity Insurance Company, FIC, First Fidelity Trust, another one, AXA, AXA, AXA Holding, all look-alike companies. After Donaldson, one of our defendants in this case, was sued, I took his deposition, and I said, Steve, you seem like a very nice guy to me. Are you working for Fidelity Insurance anymore? He says, oh, no, I'm not working for Fidelity Insurances. Well, Steve, who are you working for? And now remember, all this is on video, so when you get to a jury, you play it, and he's testifying. I don't have to read it. It's better if he's there, because he's looking at himself, lying through his teeth. Steve, what are you doing now? Well, I'm working for Chase, Private Wealth Management. Oh, is that Chase? You know? Oh, no. I work for, I can't remember who it was, Stanley Chase. He opened up his own investment firm. I'm running the private wealth management portion of that. This is what these people do. I'll go so far as to tell you that one of the things that was particularly outrageous in our case was that we found a certificate of incorporation that was signed by Josh. I believe it was Josh, but it was one of the defendant's sons. A certificate of incorporation for Lloyd of London. And it was filed in St. Vincent and the Grenadines. We had our investigator get the application. It was signed, and it was used when people said, well, what about reinsurance? Well, we got reinsurance. We use Lloyd. incredible, just incredible. So, the defendants, Dwayne, Keithley, Steve, I took all their depositions, all of them videotaped, all of them used. We used the depositions and motions for summary judgment that we filed during the litigation. We filed CD-ROMs with the fact finder. It ended up going to an arbitration. A portion of it went to arbitration, a portion of it was settled. The settlement was for a total of $23 million. Those were assets that the Vento family got back about 2 years after litigation started. And the reason there was a settlement is because there were 35 other plaintiffs that were suing Fidelity in the state of Texas, trying to get their money back that had been invested by Critfield and Donaldson and Lake in something called noble royalties. Many people have probably heard of noble royalties. Very, very good performing asset. But the plaintiffs, in our case, and the other plaintiffs didn't own any of the noble royalties. Alliance LLC owned the noble royalties, and you can see they're one of the defendants. And Alliance LLC was wholly owned by Dwayne Critfield. Alliance, the other one that's over here, another Alliance Royalties, Inc., actually had a note that was given to whoever was a holder of a policy, and that note required that Alliance Holdings pay them back. So in reality, what they did was they used a scam so that you didn't own anything, but there was a note that required that you be paid back. Just amazing things.
Alan, tell them about the quarterly reports, where they actually named the investments like the CDOs, which we really didn't own, but they were in whom?
Every investment that was made by them, I shouldn't say everyone, because maybe it wasn't everyone, but practically every investment where they used their internal methods to divest their investors of their monies, were set up in two separate categories. I own the asset, but now I owe to you pursuant to a promissory note. So it was completely illusory. And the statements that were given to the investors never showed any of that, because they would look at statements and they had every right to believe that the statements showed what they owned, when in reality they owned notes, debt, rather than the asset. The holding company is Alliance Holding Company. And there was testimony that there were a number of other entities under it, including Fidelity Insurance Company, AXA, First Fidelity Trust. Underneath that, another company that was registered as a broker-dealer in the Bahamas called Westminster, Hope and Turnberry. It ended up being a huge toxic structure, because there was simply no transparency, there was no ability to ask questions, and when people wanted to find out what they owned and if they wanted the investments that they were entitled to have, there was a delay. The delay was because all of the policies that they issued say that you don't get any benefits from any of your investments that we're making for you as part of this estate plan until 2016. That allowed them to continue to bleed it, so that when 2016 comes around, there's simply nothing left. Fidelity Insurance Company, I mentioned before, a look-alike. First Fidelity Trust, and AXA Holdings, another look-alike. Westminster, Hope and Turnberry, the investment arm. Common directors for life, Critfield, Lake, and Donaldson. Some of the things that Fidelity Insurance Company did in order to lure its victims was to present PowerPoints to them, guaranteeing payments not subject to investment risk. Guaranteed return is 8%, secured by diversified portfolios. But once the victim was brought in for slaughter, there was no way out. You were in, the money was gone, and you would get statements from them showing what you presumably owned, but you could never get anything back. It was impossible to get anything out of them. In the continuing investigation that we did, and now remember, we've got the lawsuit against the attorney defendants. We're proceeding against Crithfield and Lake and Donaldson and all the other companies, and we're doing our video depositions, and we're continuing with the investigation. One of the things that the defendants did in order to thwart the plaintiff's ability to seek recovery and justice for the claims that they owned was they started commencing litigation against us. So we ended up with, I believe, 7 separate lawsuits. There came a point in time when we were just looking at the amount of money that was going out for legal fees, and it was an absolutely astonishing thing. The red flag that initially caused Dick Vento to question what was going on was the transfer of the private annuity obligations that went from the Cayman Company, which was Lighthouse, over to Fidelity Insurance Company. And there were obligations that were supposed to be complied with under the private annuity agreements that would have had the Ventos paid several $1 million a year until the funds that were in the private annuity agreement and those obligations expired. And when the first payment wasn't made, and this was before the litigation was commenced, I remember a conversation that I had with Mr. Vento, and I said, Dick, you know, this just doesn't seem right. You've got all this money. I mean, it's in black and white. Lighthouse agreed to it. All the money went over to Fidelity. Fidelity obviously assumed those obligations. What does Fidelity say? And the response is, Fidelity says they're not responsible for it. I said, well, how can they say they're not responsible for it? I mean, it's in Fidelity Insurance. I've never seen anything like this before in my life. It's in writing. It's in black and white. And then we started sending letters and asking for explanations, and they just denied it and refused to make payments. And that really is what precipitated the proceedings. So we have claims that we brought in the United States of America. The defendants are all sued. They all claim that they are not subject to the jurisdiction of the court. We don't own any property in the Virgin Islands. We sued in the District Court of the Virgin Islands. We have never done business in the Virgin Islands, despite the fact that we've got agreements that are in the Virgin Islands. We don't have any assets in the Virgin Islands, and therefore you can't sue us in the Virgin Islands. They then bring claims against us that I mentioned before. We then, in an effort to try to secure compensation for our clients, then consult with foreign lawyers because we would like to have the assets seized. We brought proceedings for preliminary injunctions and for temporary restraining orders, which can be very cumbersome unless you have judges who give proper attention to you, and many of them don't. And, you know, I can't really blame them because they are very, very busy, but they seem to never get to things that are extremely important, like motions for preliminary injunctions. Eventually, because of the litigation that we had in Texas that was intended to seize the noble royalties, and because now there was an interpleader action, is, for lack of a better term, I have a pot of money, and Mr. Jones says that I owe money to him, but Mr. Smith and 30 other people say that I owe the money to them, and I don't know who to pay. So I'm going to come into court and I'm going to bring what's called an interpleader action. So Judge, you tell me who to pay because I don't want to pay people twice. So Noble Royalties goes into the Texas court and they bring an action for an interpleader so that the court can tell them who to pay. Now, the Vento family had the largest claim in the interpleader action, and I think that the defendants in this case were probably scared that we had so much evidence on them at this point in time that it was a fait accompli and we were going to get what we wanted. So we sat down and we mediated a large portion of the case that resulted in our getting our Noble royalty interests back, and also private equity and private investments that were made. There is a confidentiality provision in the settlement agreement, but I can tell you that it was fairly substantial. More than 70%, 60 to 70% of the claim was settled by the settlement agreement. And immediately after the defendants enter into the settlement agreement that is signed by them, all of them personally, they take the assets that they're supposed to hold for us as security and a pledge for the litigation that was still pending, and they convey it out to 2 more offshore companies. So we're dealing with some really, really interesting people who are bereft of any morals.
Well, the other thing, Alan, that you should mention is that even though we've got the settlements, that we do not have the assets. Okay, we'll get to that. Okay.
So I think maybe by now you're seeing that sometimes when you have situations where you think that your claim may be very, very solid and very good, and that the assets are going to be there so that you can recover once you're able to obtain your justice, you have to be prepared for the long haul because, and this is what the next PowerPoint says, even though they agree in writing, they agree that you're going to have these funds, they convey them out, and then they make you chase them for them anyway. More and more work. And this is really their business. The one thing that rings in my mind when you go to the initial documents that were executed by the Vento and all these other victims is that they tell you that this is an asset protection trust, an APT. This is something that will allow you to make sure that your money is safe, allow you to make sure that your money is secure, and that nobody will be able to get your money, even if you are a gynecologist and you unfortunately nicked something and you've now got a $50 million verdict against you, they cannot get it. But the one thing they don't tell you is that if you want your money back, you can't get it either. It's a very unfortunate thing. So here's the provision of the settlement agreement that requires that they assist in accomplishing the completion of their obligations, and that they will even help with judicial intervention. The claims that we have in foreign countries, the claims that we were required to bring in foreign countries, different standards of proof, claims in the Bahamas, Marevas, Bankers Trust, and Anton Pillar proceedings, and really a tremendous amount of expense. The next shot is interesting. If you take a look on the left side, you'll see that it says Fidelity Insurance Company. If you go down a little bit further, you're going to see that it's got the name Dwayne Crithfield in it. It's got Keith Lee Lake in it. It's got Gina Brunley, office manager, in it. And it talks a little bit about what they can do for you, life insurance, trust benefits. That was printed off 3 days ago from the web. The next one, Fortress, that was printed off 5 days ago from the web. Fortress Trust. The presentations that they make are world-class. Just amazing. Citadel Insurance Company has now taken over all of the activity of Fidelity Insurance Company. We suspected that Citadel Insurance Company was going to step in after Fidelity Insurance Company had its reputation besmirched. And we were right. Now Citadel is doing everything that Fidelity was doing before, but they just have a new name. More and more lookalikes. I'm kind of coming down to a little bit of a summary here now, because I think when I take a look at the success that we had in this case, and we compare it to, for example, Madoff, the victims in Madoff, most of them have not gotten back anything yet. But I believe that it was between 7 and 15 cents on the dollar is what they were able to recover. People who were paid that shouldn't have been paid, they're taking clawbacks and getting the money back and saying it's got to be spread out among all the victims. So many victims, and they couldn't find a way to compensate these people. The only way that we were able to do this was by recognizing that we needed to know where the money was before we started. We needed to know who the players were and where they got their income. We needed titles. We needed to have a deep throat. We needed to have somebody who on the inside was so outraged, and we found him. We found one person on the inside who was so outraged that when I met with him, he said, when I found out what they were doing, and this is a man who was an insider of Fidelity Insurance, he said, when I found out what they were doing to the Ventos, after the Ventos were saying, where is my private annuity payment? Tears came to his eyes. And he said, I couldn't stand myself for working with people like this anymore. His name is in our pleadings. You remember when I took John Sylvia's deposition in Port Washington? Now we're talking about video depositions that went around the country and in foreign countries. Places where sometimes you don't feel real welcome when you're taking a deposition of the most prominent lawyer in Anguilla, Keithley Lake. And then he says, I never envisioned myself to have a conflict of interest while he is staking out millions and millions of dollars when he is the trustee. Absolutely amazing. So without the investigation, right at the beginning, without having the ability to analyze the types of claims that exist, that can be pursued, without having the funding that is necessary in order to do this, without having attorneys you can trust, the ability to read hundreds of thousands of documents in claims like this, you can't win them. You can't win them because they will use every dime they have to fight you. The only way you can win them is, number one, due diligence. Number two, a great investigation team. Not good, not traditional, not white bread, the real thing, the ones who are boots on the ground. And then, patience, planning, and deep throat. After we put this together, we ended up taking the last quarter part of it and going to an arbitrator who was acceptable to all the parties. The arbitration in the case took 2 weeks. Our presentations to the arbitrator after the discovery was all done was primarily done by video. Our opposition was not done by video. They brought in their live witnesses. Their live witnesses were Lake, Crithfield, and Donaldson. That was it. We had forensic accountants. We had an economist come in. We showed how much we invested, how much we got back as a part of the settlement, the breach of the settlement agreement, and finally, we showed them the bottom line. And we ended up with about $10 million. So when we add the 23 that we got together with the other 10 million, almost 100% recovery. Almost 100%. The amount of money that was spent to do that, I'm sure, was well in excess of $1 million.
Per year.
You know, I've never heard that complaint before. This case was a very interesting case for me, and I think was very satisfying for our law firm to be able to call this a tremendous success. That it was able to yield and to bring back what had been stolen and converted from really what is a wonderful, terrific, middle-class, hard-working family who achieved the American dream. Unfortunately, most people cannot afford to do this. You know, we came across so many victims in the Noble claims who invested maybe $200,000, $500,000, $1 million. That's gone. It's gone. You just cannot afford to pursue those types of claims unless you've got a lot of luck and unless you've got a deep throat. Dick, did you want to say anything in closing?
No, I guess, you know, one of the important messages is they clearly have asset protection, but they don't, you know, in all these seminars, like this one, that I've been to for family office management and things of that nature, what you never hear is that if the people that you're dealing with are dishonest, you're going to have a real tough time getting to them in places like Anguilla. And we still haven't. We are still working on that. And then if the assets are held in the Cayman Islands, okay, it's tough to do. You know, a lot of these attorneys claim to have the ability to go after all of them. Well, fortunately, I had attorneys in Caymans, you know, Maples, and had attorneys in Anguilla and other places because of some of the international business that I'd done and things like this. So I was already in a better position than most people are. And I realize a lot of the attorney firms here claim to be able to help, but, you know, if they don't have the ability, if they're not licensed to be an attorney in all of these different places, and they have spread out the operation like these guys did, then your attorney firm has to go has to have alliances. And I'm sure that in this whole conference, there's capabilities to do that and to get that coverage, but that takes a lot of time and a lot of money too. And you pick up a new attorney in Florida, and they wanted a retainer fee. My retainer fees would have been incredible if I had not already had attorneys all over the country, way too many attorneys, okay? And because I'd had a lot of other attorneys too all over the place, okay, I'm willing to fight, you know?
Right now, there is litigation pending in the Vento case in Nevis, in Anguilla, in the Bahamas, in the state of Florida, in the state of Texas, in the state of North Carolina, and the state of New York. Judgment, confirmation of judgment, enforcement of judgment, orders of seizure are all out there. So despite the fact that we have recovered and received substantial amounts of money, it's out there. We know where it is. We're going after it because Dick Vento says, maybe you fucked me, but you're not getting away with it.
Well, my daughters own about 99% of everything. Right? That happened a long time ago.
Any questions?
Alan, can you talk a little bit about the interim measures that you pursued in the foreign jurisdictions? Also, whether in the course of the domestic litigation, if you attempted any interim measures. By interim measures, you mentioned Morava rulings or Morava injunctions, Anton pillar orders. What has your success rate been with those requests, and have you tried similar measures in the U.S. courts?
We have.
Morava rulings not valid.
We have. What we did was we consulted with foreign counsel at a very early stage in these proceedings, and we were advised of various techniques that could be used under Banker's Trust and for Anton Pillar and for Morava for searching and for obtaining records pre-suit. And to be very frank with you, we were very disappointed because even though there is some good, solid British law on this, in the island jurisdictions, we found that the level of proof that would be needed would be equivalent to an admission on the part of the defendant in order to get it. So we were not successful in getting the types of orders and rulings that we wanted to get in A, the Bahamas, B, Anguilla, and I think there may have been some other proceedings that were brought as well. In the U.S., we were able to get hearings and have the applications for temporary restraining orders heard, but the judge that we were in front of is the type of judge that says, I'm going to merge this issue with our trial, and kicks the can down the road. Very, very difficult. Had we not done what we did in Texas and raised the level of concern on the part of Noble, and we're also doing that in some other jurisdictions where we have some other assets that we found, because of their concern that we're going to have to pay twice, we forced them into court saying we're not going to pay anybody until a judge says, you owe it to the Ventos, you owe it to the Wents, you owe it to the Smythes, you owe it to, and those are real names. That's what we waited for, that's what we got.
What about in New York? Did you at any point consider going to the Southern District of New York to conduct a discovery or to seek a global attachment order?
We did not go into New York. We had already commenced our proceedings in the Virgin Islands. We felt that there was jurisdiction in the Virgin Islands. We were attacked on all fronts with respect to jurisdiction. And in the state of New York, it would have been very difficult for us to show that there had been substantial contacts in the state of New York. The only reason we were able to get into New York, and we are there now, was because we found that the defendants were selling off assets that were in the Bahamas in order to fraudulently convey out their assets so that they would be beyond our reach. Now think about this. We're in the Virgin Islands, the assets in the Bahamas. We found out that they signed agreements with Concierge Auction in Manhattan in order to have an auction house sell them off. But what they did was they had the proceeds of the auction sale. Commission went to New York. It's not their money. The actual asset was in the Bahamas, and the transfer of the funds were going through Texas. So when we brought proceedings to seize those assets, I still believe that we should have been able to get them, but we were unable to seize them. But we have fraudulent conveyance action that's coming up against them for doing what they did and pulling the wool over Judge Carol Edmead's eyes because she was in the process of issuing a seizure order, and before it was signed, they hurried up and sold the property. And that's what we were dealing with.
Yeah, I'm just wondering for Mr. Vento, based on this experience, if he were to turn the clock back, what would he have done differently in terms of setting up all these discussions?
You know, I'm glad you said that. In personal injury cases, you know what I say to the jury? I look at them and I say, you know, there's a time machine in the corner over there behind the coat rack. And if we put in a coin, this will never have happened. So I think that's a great question. Dick, can you answer the question?
Yeah, I think, as I said earlier, due diligence, check out who you're dealing with, and have more time. We were surprised when Agilent made an offer. Well, we had the company for sale for over a year with Smith Barney and not getting worth a damn thing out of it. Moved to other investment bankers, and nothing was happening. Then all of a sudden, like in 1.5 months, we had a bidding war going on, a shark feeding frenzy for the company. Angela came through with a good one in time, and that put a little pressure on us. I had all that time before to do things, and I didn't do it. Okay, took too much time. I should have taken the time and did it before. Everybody thinks, well, God,
You know, but Dick, you had good tax advisors at that point. You had Bob Colvin, you had Robert Kipp, you had some...
he did his job, but
you had some good
I had
people.
one guy over here. I had Debbie Cochran did a great job of the trust funds. Bill Powers did whatever I told him to do with a bunch of LLCs out of Colorado. But I didn't have a centralized one organization that could watch the whole thing, okay? And that's where Handler, Thayer, and Duggan was going to come in, all right? So I should have been more diligent in doing the background check on Handler, Thayer, and Diligent. I should have been more diligent with respect to picking Alliance Fidelity to take everything that Colvin had done very well and then move it all over to Alliance Fidelity under the guidance. Handler, Thayer, and Duggan told me to do that, okay? To move it over there and put all kinds of justification together. A lot of it was BS, it turned out. Okay? And you know, another thing to do is, you know, have the clients go to seminars like this and get and talk to a lot of people. Yeah.
Can you tell us a bit more about what you were doing in Belize?
The primary activity we're involved in Belize was finding out where assets were located, and we focused in on the lawyers. I, as of this day, still do not know how Pete was able to get the information that he got. He got inside banks. He got inside and found out amounts of monies that were on deposit. And as a result of that, it put us in a very good position, I thought. But he was able to do that in other places other than Belize as well. And that's as much as I can tell you.
And who is Pete?
Pete is our private, he was the head of the private investigation team. Former FBI agent and former DEA agent, and he's been in law enforcement most of his life. Any other questions? It's been a pleasure being here. I want to express my thanks to Dave for inviting me and for inviting Dick to come to the seminar. It's been informative for us and very helpful, and I hope that everybody enjoyed this brief lecture. Thank you.